Earlier today, I spoke with Connecticut Democratic Senator Richard Blumenthal about a whistleblower complaint that alleges that ICE told its agents through a memo that they no longer need a judicial warrant in certain cases to enter private residences. Here is our conversation. Senator, based on your understanding, what has changed when it comes to policy regarding federal immigration officials entering a private residence, and what do you fear the ramifications of this new policy could be?
What has changed, and Americans should be aware of it, in fact, very afraid of it, is that ICE agents have been told in this secret policy that they can break down your door, ransack your living room, terrorize your kids, arrest and detain you without a judicial warrant, without consent or an emergency, and without a judge approving what they're doing. That policy is a break, a radical and drastic change, because what they're relying on now are the so-called administrative warrants, which are simply signed by another ICE official rather than a judge. It's a violation of the Fourth Amendment. It is legally and morally abhorrent. It reflects and exemplifies what's happening in real time in America today, the abuses, dangerous and destructive policies that are occurring in Minneapolis and all around the country, documented even before Minneapolis and Renee Good's death in a report that I did as a result of an investigation as the ranking member on the permanent subcommittee on investigation. That's the reason the whistleblowers came to me with this secret policy, and we have now disclosed it for all America.
When the DHS says, as it has, this particular new policy only applies to those who have received a final removal order because of their unlawful immigration status, does that lessen your concern at all?
In the least, Major, because a removal order can be issued at the whim of the ICE official. And speaking legally for a moment, as a former prosecutor, I was the U.S. Attorney in Connecticut as well as the State Attorney General in Connecticut for 20 years. The principle that you cannot enter a person's home without a judicial warrant has been the law of the land for 250 years. It is enshrined in the Fourth Amendment. A removal order makes no difference whatsoever. What's additionally alarming is, frankly, that the head of ICE thinks that's a rationale for violating constitutional rights. And this memo, this secret policy, links the lawlessness now occurring on the streets of Minneapolis and around the country to the top levels, the very top hierarchy of ICE and the Department of Homeland Security, and they should be held accountable. And I am going to continue my investigation through the Permanent Subcommittee on Investigation, as well as calling for hearings and voting no on appropriations if they can't establish guardrails and safeguards to protect constitutional rights.
Senator Blumenthal, the Vice President, JD Vance, addressed this today in Minneapolis when asked about it. I want to play that sound for you and get your reaction. Please listen.
The Department of Homeland Security really has proposed in the Department of Justice is that we can get administrative warrants to enforce administrative immigration law. Now, it's possible, I guess, that the courts will say no, and of course, if the courts say no, we would follow that law, but nobody is talking about doing immigration enforcement without a warrant. We're talking about different types of warrants that exist in our system.
Different types of warrants. What does that mean to you, Senator Blumenthal?
May sound technical to the everyday American, but it matters drastically, and the Vice President knows better. We're fellow graduates of the Yale Law School, and he knows the difference between an administrative warrant and a judicial warrant. The judge who approves a judicial warrant will demand of an agent, whether it's the FBI or the DEA or the local or state police, show me probable cause that you have a reason to break into this home and arrest someone. Show me the fact. An administrative warrant is issued by another ICE agent or some official in the Department of Homeland Security. So JD Vance is covering himself a little bit by saying, oh, the courts may tell us we're wrong. In fact, the courts will tell you you're very wrong, absolutely wrong, if you use this administrative warrant to violate the Fourth Amendment.
Senator Blumenthal, am I right in remembering that many of the immigration judges who might do this work were fired in the early days of the second Trump administration and then replaced? Am I correct about that? And does that have implications for what we're talking about?
The hollowing out of the judicial apparatus of the Department of Homeland Security and the Department of Justice is weakening due process in this country for asylum claims that may be made. So it is relevant, absolutely. But administrative officers or administrative judges are not the ones to issue warrants to enter someone's home. It is a judicial warrant that is required under the Constitution. And the courts could tell me I'm wrong, but it will be a break from 250 years of established precedent. And by the way, as you well know, Major, we all should know, one of the reasons we rebelled against the British was they were breaking into our home without any warrant and treating us as simply second-class citizens. It wouldn't happen in the UK under their constitution, perhaps, even at that time. But we should stand up for the Constitution and say, we'll provide the resources for the administrative process, but to enter a home requires a judicial warrant, not the whim or even the suspicion. It requires a judge saying it's okay.
Connecticut Democratic Senator Richard Blumenthal. Senator, I appreciate the time. Thank you.
Thank you. Take care.